She went to cancel her wedding and left with a false diagnosis. A woman walks into a wedding venue to pick up her belongings after a canceled engagement and walks out with a diagnosis that changes her life. The only problem, the diagnosis was wrong. The wedding had been planned for 14 months. The venue was a restored 19th century mill in the rural countryside. Exposed timber beams, a waterfall garden, the kind of place that cost $12,000 just to reserve. The couple had paid in full. Then, 6 weeks before the ceremony, the engagement ended. No dramatic betrayal, no scandal, just two people who finally admitted they were wrong for each other. By all accounts, it was as civilized as a breakup can be. The woman, referred to throughout the proceedings as the plaintiff, returned to the venue on a Thursday afternoon in early October to collect decorative items stored in the bridal suite. The venue's on-site coordinator, a licensed practical nurse who had transitioned into event management, was present during the visit. What happened next is where the two sides diverged sharply. According to the plaintiff, she mentioned feeling dizzy and short of breath while climbing the venue's main staircase. The coordinator, drawing on her medical background, examined her informally, checking her pulse, observing her coloring, asking about her symptoms, and then told her, with apparent confidence, that she was likely experiencing an anxiety episode brought on by the emotional stress of the visit. She advised the plaintiff to sit, drink water, and avoid driving for 30 minutes. The plaintiff followed that advice and went home. Over the next 3 weeks, her symptoms worsened. When she finally saw her physician, she was diagnosed with a previously undetected cardiac arrhythmia, an irregular heartbeat that, left unmonitored, carried a meaningful risk of complications. Her cardiologist testified that earlier intervention would have been ideal and that the 3-week delay, while not catastrophic in her specific case, had allowed the condition to progress without management. The plaintiff filed suit against the venue for $214,000, covering medical expenses, lost income during her recovery, and damages for emotional distress. Her argument was precise. The coordinator had not simply offered comfort. She had offered a diagnosis. And because the coordinator held a valid nursing license, the plaintiff trusted that assessment the way a patient trusts a clinician. The venue, her attorney argued, had allowed a licensed medical professional to practice medicine on their premises and should be held liable for the consequences. The venue's defense was equally measured. The coordinator never claimed to be acting as a nurse that day. She was acting as an event coordinator. The conversation was informal, voluntary, and clearly outside any professional clinical context. No equipment was used, no records were kept, no one held themselves out as providing medical care. The plaintiff, they argued, was an adult who made her own decision to delay seeking treatment. The venue did not cause the arrhythmia. The venue did not prevent her from calling a doctor. They expressed sympathy and drew a firm legal line. Both sides were believable, and then came the deposition transcript. During discovery, the plaintiff's legal team obtained a text message the coordinator had sent to the venue's general manager the same evening of the visit. In it, she wrote, verbatim, "She seemed off. I checked her out nurse style, told her it was probably nerves. Might want to note it in case anything comes back." The phrase, nurse style, became the fulcrum of the entire case. The defense argued it was casual language. The plaintiff's attorney argued it was an admission. The coordinator, when deposed, said she couldn't recall writing it. The judge, a 22-year veteran of civil court, sat with the case for 11 days before issuing her ruling. She found in favor of the plaintiff, but not for the reasons either side anticipated. She rejected the medical malpractice framing entirely. Instead, she ruled on negligent misrepresentation, determining that the coordinator had presented informal reassurance in a way that a reasonable person, knowing the coordinator's background, would interpret as authoritative guidance. The venue had benefited from employing someone with medical credentials and had never established a clear policy prohibiting the use of that background in guest interactions. That gap in policy, the judge ruled, was the venue's liability. The awarded damages came to $89,500, substantially less than the $214,000 sought, but real. The emotional distress claim was denied. The medical and income losses were partially granted. The venue's insurance carrier paid within 60 days. The coordinator resigned 2 weeks after the verdict. The plaintiff, by all accounts, is managing her condition well with medication and regular monitoring. The former fiancé, who had no involvement in the case, reportedly sent her a card when he heard. She did not respond. What the ruling quietly established is something the legal community noted without fanfare. The line between human kindness and professional liability is thinner than most people realize. The coordinator almost certainly meant to help. She almost certainly believed she was helping. She may even have been partially right about the anxiety, but meaning well has never been a legal defense. So here's the question worth sitting with. If a professional leaves their credentials at the door when they change careers, does their responsibility leave with them?